much. A very good morning. Dear colleagues, welcome to members of the public too, and to NGO representatives as well as interpreters and everybody else in conference services. Once again, a very warm welcome to the delegation from Namibia. There's no doubt that you worked very hard indeed overnight in order to press ahead with the consideration of the second periodic report of your state party. This is meeting number 3237 of the Committee on Human Rights. We're meeting in a public session to consider the second periodic report of Namibia. Yesterday, we ran out of time just when His Excellency was beginning to answer the whole host of questions that the committee had addressed to the delegation in the first part of the review. So today we will proceed as follows. The delegation will have 3 minutes available to complete the answers that they began to provide yesterday, and then we will move on to hearing follow-up questions together with the questions from the second part of the list of issues. So, just to make sure that we're all clear about that, let me repeat it. We're going to be addressing follow-up questions to the delegations together with the questions that relate to the second part of the list of issues. So, without further ado, and once again wishing the Republic of Namibia and its delegation a very warm welcome, I give the floor to His Excellency, the Minister of Justice, Albert Kawana, allowing him to complete his statement. You have the floor, sir.
Thank you very much, Honorable Chairperson. Two issues remained outstanding yesterday, one being the so-called mass graves in the Caprivi, which were allegedly discovered in 2003 and 2009. Up front, I would like to say categorically, there's no such thing as mass graves in the Caprivi. Incidentally, that region has also been renamed. It's no longer Caprivi, a colonial name. The residents of the region preferred to call it after the very great river that sustains life in that part of our country. It's now called the Zambezi region, named after the great Zambezi River. I don't know where this information comes from. I recall about 20 years ago, another allegation was made that there was a mass grave in one part of our region called the Kavango. We challenged those who made that allegation to provide them transport free of charge, to provide all journalists who were interested free of charge, to go and show us the mass grave. Up to now, 20 years on, we are still waiting. And it appears that the same allegations are repeating themselves again to tarnish the good name of our republic. Honorable Chairperson, I want to state in no uncertain terms that the territorial integrity of the Republic of Namibia is not negotiable with anybody. We will not take kindly to any person who will disturb the territorial integrity of Namibia. I'm aware that in this building, there were those years in the 20s, the League of Nations, which defined the boundaries of Namibia, together with two treaties, international treaties, the Anglo-German Agreement of 1st July 1890 defines the international boundaries of Namibia. The other one is a 1888 treaty between Germany and Portugal. These are the two treaties which define the boundaries of Namibia. And the territorial integrity of Namibia stemmed from those two treaties. Subsequent to that, the United Nations itself, through the UN High Commission for Namibia, UN Council for Namibia, numerous United Nations General Assembly, United Nations Security Council resolutions maintained the territorial integrity of Namibia. There are maps, United Nations maps, produced from time to time, defining the current territory called Namibia. And therefore, as far as we are concerned, this issue is non-negotiable. 20 years ago, the so-called mass graves, which were allegedly committed by then Plan or SWAPO, turned out to be mass graves which were committed, at least the atrocities were committed by the South African apartheid regime. I can also, with pleasure, invite members of the committee to go to that area, interview the civilians. They will tell you the number of people who were killed during the war by the South African troops that time. They will tell you the names of people who are buried in that grave. It's not SWAPO, it's not the Angolan forces, as it was alleged then. I also challenge, as I say, those people who are saying they are mass graves to go and show us those mass graves in Caprivi. And with pleasure, I invite the members of this committee to accompany us to go and see those mass graves. So as far as the government of the Republic of Namibia is concerned, this is a non-issue. Now, regarding the 2,000 members of SWAPO who have disappeared in the hands of SWAPO, what I want to say is this, Honorable Chairperson. We had a war of liberation, and that war stemmed 24 years. Armed struggle, that is, 24 years. And during that period, it was the most unfortunate war, but we were determined. And that was the war which was sanctioned by the United Nations, that the people of Namibia had a legitimate cause to take whatever means possible to gain their independence, including armed struggle. And we pursued this armed struggle for 24 years. Following the adoption of the United Nations Security Council Resolution 435 for the implementation of the roadmap to Namibia's independence, the United Nations went to Namibia, they supervised the free and fair elections. SWAPO won those elections. But before the elections, the parties came together and agreed that there must be a policy of national reconciliation. And that proposal came from SWAPO. We agreed, and there was an amnesty proclamation or amnesty law that was passed to make sure that from now on we move as a nation. We don't want also to be reminded of those dark, what we call history. Now, that proclamation or the law granted amnesty to all the parties, be it the South African troops or the SWAPO troops under the People's Liberation Army of Namibia and their leadership collectively. And we said that was a very sad history. We apologized as SWAPO because we have nothing to hide regarding this very dark history. The then Prime Minister of the Republic of Namibia, current President, even in the Parliament, he said that was most unfortunate history, but as a nation, let's move together. We moved together. The forces which were fighting us, together with plan members under SWAPO, we formed a one national army. We formed one police force. We formed one prison service. And together, today, we have a solid army, very, very professional in Africa, well known for that. We have also a police force, professional police force that is known in Africa, and also the prison service. And this is the chapter we want to be known, to say Namibia today is one of the best governed. When it comes to good governance, it's one of the best governed country in Africa. So in this regard, I'm given 3 minutes. Otherwise, I could have said more. But otherwise, I say amen. Thank you very much, Chairperson.
Muchas gracias a usted, señor.
Thank you very much, Your Excellency, Minister of Justice. Now, this is a public meeting, and I would therefore venture to say that whatever the committee members say have nothing to do with the right to territorial integrity of a state. They are only commenting on the implementation of the covenant within the state party. Whatever the members of the committee say, it in no way questions the territorial integrity or the sovereignty of any state. Colleagues here have expressed legitimate concerns. And that is why I now open the floor for comments from colleagues so that they can have an opportunity to ask any follow-up questions that they feel are appropriate, and also to ask questions relating to the second part of the list of issues. Now, I have some speakers on my list already, and it's a very great pleasure for me to start the ball rolling with my dear colleague, Ms. Cleveland.
Thank you, Mr. Chair, and I would like to thank the delegation for the information they have provided to the committee. Yesterday, I asked a series of questions relating to issue 11 regarding the regime for protecting victims of domestic violence, and I don't believe I've received an answer to my questions relating to the plans the state may have with respect to expanding the personnel who are empowered to issue protective orders beyond magistrates in areas where magistrates aren't available, to allow them to be issued outside of working hours, to simplify the process for obtaining protective orders, improving access to shelters, improving protection for survivors, and so forth. So we would welcome any further information you would like to provide us. Yesterday, in your responses, you referred to the fact, I believe, that you are contemplating legislation which enhances the rights of persons with disabilities, and it would be helpful to the committee if you could provide more detail regarding that legislation. In your responses, you stated that no one is being discriminated against on the grounds of sexual orientation and gender identity, but information before the committee suggests that there are various ways in which LGBT persons are discriminated against as a matter of law and practice. One of those is an issue I raised yesterday, which is that under your Combating of Domestic Violence Act, it is our understanding that protective orders are not issued and cannot be issued in situations of domestic violence involving same-sex couples. And that is therefore an important way in which they are not protected by your law, and that your Labor Act used to include sexual orientation as a prohibited ground for discrimination, but that provision has been removed. Information before the committee indicates that you invoked the common law crime of sodomy as a justification for not distributing condoms in prisons, with severe health implications for your prison population. And there are multiple reports before the committee of discrimination, harassment, and violence against LGBT persons, including by the police and including cases of so-called corrective rape, which have not been investigated and prosecuted. With respect to racial discrimination, I appreciate the answers that you've given regarding the contemporary regime you have in place. It's our understanding, though, that there are a number of laws remaining on the books from the apartheid era that do provide for discrimination or do allow for discrimination on the basis of race, which have not been repealed and are therefore theoretically still active. So I would welcome information whether you're contemplating repealing those. You addressed sterilization, forced sterilization, And my follow-up question is whether or not you have contemplated developing formal guidelines for establishing informed consent for procedures such as sterilization or other medical procedures, so that there are clear guidelines protecting individuals in these contexts. And then finally, with respect to the issue of Ebola, in light of your response yesterday, I was wondering whether you are contemplating adopting legislation that would in fact provide that the bride price could not be demanded to be returned upon the dissolution of a marital relationship. So those are my follow-up questions. Thank you. Do you want me to ask my new question?
Yo quisiera que si usted...
I think it would be appropriate for you to be asking the questions relating to the second half of the list of questions.
For the questions for today, with my apologies, I will be addressing issues 15, 16, and 18. Issue 15 addresses elimination of slavery, servitude, and forced labor, and efforts to protect against child labor. We requested statistical information on child labor in our list of issues, but did not receive it from the state party, although some such information has been provided by civil society. So I would ask whether the state party in fact collects and reports statistics on issues relating to child labor, forced labor, and trafficked persons, and if so, where that information is located. With respect to the question whether children between 16 and 18 may legally work under hazardous conditions, we understand that Article 3 of the Labor Act prohibits nighttime work, underground work, or work in a mine for children of that age, but also that the minister may permit such work by regulation subject to restrictions. So could you please tell us whether any regulations have been issued by the minister allowing for such work, and if so, what work they allow for and how many children they implicate? Your response to the list of issues indicates that it is possible for labor inspectors to access private farms if access is denied that labor inspectors may approach agricultural regional employers' forums in order to secure access. But civil society has reported to us that lack of access to private farms is a major obstacle to enforcing the child labor laws and other labor laws in Namibia. In this regard, could you please inform the committee how many labor inspections of private farms have been successfully conducted in the last 2 years? And in how many occasions was an effort to inspect a farm denied, and in each case, how that effort was resolved? Do you also have plans to allow or provide labor inspectors to use vehicles or provide them with vehicles so that they may carry out inspections? More generally, can you provide the committee with information regarding the budget of the Labor Inspectorate, the number of labor inspectors you have, the mechanisms that exist for bringing potential labor violations to the inspectorate's attention, the total number of inspections conducted in the last 2 years, the number of compliance orders issued, and the results of those compliance orders? Do you have plans to increase the budget and/or number of inspectors? And what mechanisms exist for enforcing sanctions against offending employers for non-compliance with the child labor and/or minimum wage laws? Please identify for the committee how many incidents of insufficient compensation or prolonged working hours for farm workers or domestic workers have been found in the last 2 years, and what actions were taken by the government in response to these actions. Your report indicates that 2 cases were prosecuted in 2015, one resulting in an acquittal and one resulting in a sentence of 13 years, but you don't provide us with details, and I would appreciate information regarding what the factual and legal issues were in those cases. Finally, with respect to trafficking, can you please inform the committee what changes are planned, as you indicate, for the draft bill on anti-trafficking and the anticipated timeline for its enactment? It has also been reported that following the release of the U.S. Department of State's 2015 Trafficking in Persons report, the State Party established a Ministerial Committee to address the issue of human trafficking. Could you please provide us, therefore, with information regarding the work of this committee to date and its plans going forward? Turning to issue 16, which addresses length of pretrial detention, length of appellate proceedings, and enforcement of the 48-hour rule. This issue has a number of different components, which I will address in turn. Your written submissions indicate that the government established a criminal justice forum which reviews the legal framework of the criminal justice system, including reduction of the pretrial period. Could you please, therefore, inform the committee regarding the work of this forum relating to reduction of pretrial detention and your plans for enacting any proposed reforms into law? Can you please advise the committee regarding the average length of pretrial detention and the measures taken to reduce its usage, including whether through increasing access to bail, providing for alternatives to detention such as electronic monitoring, and/or expediting the pretrial investigation process? Your ombudsman has reported that 87 persons detained across the country are waiting for pretrial mental observation, at times for prolonged periods. Could you please inform the committee what steps you have taken in response to the Ombudsman's report to expedite the transfer of these detainees for mental observation to prevent unnecessarily long pretrial detention? Your written submissions address judicial enforcement of the rule that persons should be brought before a judge within 48 hours of their arrest. Can you provide the committee with data regarding the number of cases in which the 48-hour rule has not been complied with, as well as information regarding the circumstances giving rise to that failure and the concrete steps, if any, that are being taken to ensure compliance with the 48-hour rule? With respect to delays in appeals, have you taken any action in response to the 2013 findings of the Ombudsman regarding inordinate delays in the preparation of the appeal and the appellate record? And finally, are any persons currently detained under the Prevention and Combating of Terrorist Activities Act, or have any been detained in the last 2 years under this act? And if so, could you please inform the committee of the circumstances regarding such detention? The last issue is issue 18 involving refugees and asylum seekers. Information before the committee had asked about the protection of asylum claims for persons fleeing persecution on the grounds of sexual orientation and gender identity. Information before the committee indicates that at least one such asylum applicant recently was denied protection under your refugee law and ultimately resettled through other means. Your response to the list of issues, however, regarding refugee protection appears to imply that such persons are covered by Namibia's refugee law. In light of this fact and your statement yesterday that there is no discrimination against individuals on the basis of sexual orientation and gender identity, can you confirm that these grounds are protected bases for refugee status and non-refoulement under Namibian law? Can you also inform the committee how many individuals have sought refugee status on this grounds, and how many such claimants have been granted refugee protection? Further, Has the state party considered developing guidelines regarding the handling of refugee claims based on sexual orientation or gender identity to ensure that persons fleeing persecution on this grounds have equal access to the asylum system, such as the standards set forth in the South African Refugee Act? It is reported that some cases involving unaccompanied children have gone unprocessed for years, and that some such children have been denied asylum. Could you please indicate whether the state party has plans to incorporate the best interests of the child standard into your asylum law, and what practical steps you have taken or plan to take to ensure appropriate protection for minors throughout the asylum process? We also understand that Namibia recently agreed to allow Angolan refugees who did not want to repatriate to remain and become locally integrated, and that the state party has begun issuing permanent residence permits to these individuals. Following the closure of the UNHCR country office in Namibia and considering the relatively low refugee influx, could you please indicate if the state party is considering or willing to consider the full local integration of refugees through granting of permanent residence permits and eventual closure of the Asir camp? And finally, with respect to the case of Zhu versus Minister of Home Affairs, could you please inform the committee whether that ruling, which held that deportation cannot be imminent without a direction from the Immigration Tribunal, is systematically complied with in Namibia, including in the case of asylum seekers that have not yet been granted refugee status? Those are my questions, and I look forward to your responses.
Muchas gracias, señora Cleveland.
Thank you very much, Ms. Cleveland. I'd now like to give the floor to Sir Nigel Rodley. You have the floor, sir.
Thank you very much, Mr. Chairperson. First of all, I'd like to thank the delegation, and particularly His Excellency, the Minister of Justice, for his tour de force in answering everything from everybody, including many of my questions. I would just like to do a bit of follow-up in that respect. First of all, on the question of the tribunal of the South African Development Community, it's being reconstructed. Well, that's very nice, but it's being reconstructed, as I understand it, without the right of individual petition. And without the right of individual petition, we have enough experience in this committee to know that human rights are not well defended by an interstate complaint mechanism. I'm not sure what the significance of his reference to exhaustion of domestic remedies was. If you'd care to clarify that, that would also be interesting. Now to the issues formally before us. The question of the abortion issue, the minister, who's obviously very enlightened, was lamenting the strong role of the church in the debate in the state party, and yes, indeed, Namibia is not the only victim of that particular problem as an obstacle to introducing policies consistent with respect for human dignity. I noticed with interest the suggestion that maybe the issue should go to a referendum, according to which the people would be asked, should we have abortion on demand or the status quo? And I was a bit baffled by that. First of all, human rights are not supposed to be the subject of opinion polls, and I think it's not necessarily the best decision-making process. Second of all, I didn't really understand why that should be the range of issues to be discussed in the first place. The issues I raised, for example, had nothing to do whatsoever with abortion on demand, and this committee has not asked for abortion on demand. And on the contrary, my intervention indicated that the grounds for legal abortion, the actual substantive grounds for legal abortion in the state party, were consistent with this committee's practice so far. The issue is a rather different one, and that was the obstacles in the existing law to securing the legal right to abortion on the grounds permitted under the law. Again, I would like some focus on that question, if that's possible. We were apparently given out-of-date information on the availability of contraception. The Honourable Minister of Justice assured us that now contraceptives are freely available in clinics and state health institutions and various places. This is very encouraging. I find it a bit surprising that it's information that isn't available to civil society even now. I'm wondering what publicity the state party has given to the change in policy. On the question of harmful cultural practices, the minister, as I understood it, was basically saying, yes, there did seem to have been a recrudescence some years ago. I'm not sure if there was an implication that it's something of the past. Certainly, the information still coming to us was that as recently as 2012, the Women's Leadership Centre was commissioned by the Ministry of Gender Equality and Child Welfare to do training with traditional leaders in the Zambezi region on harmful cultural practices. And they submitted a report to the ministry which clearly indicated that the traditional leaders from all four main ethnic groups in the Zambezi region acknowledged that all of the above practices, those are the practices that were referred to in our original list of issues, that they acknowledge that all of these practices are still occurring in their communities. Am I right in thinking that they are still occurring? The response then went on to projects to avoid the risk of pregnancy, and I wasn't quite certain of what the relationship of that was to the issue of harmful cultural practices, unless these practices are actually also leading to unwanted pregnancies, which, if they are, makes them all the more reprehensible and all the more urgent to come to grips with. Certainly, I noticed that the state party is concerned to help avoid unwanted pregnancies. And if I understood correctly, he referred to the Chifoko Festival, which is designed an example of promotion of education to avoid pregnancies. I presume this, sorry, not the Chifoko, the Olufoko Festival. I hope this Olufoko Festival is not the same Olufoko Festival referred to in Insight magazine in 2014 in the Omusati region, which has been apparently spearheaded by senior government and state leaders, during which girls and young women are paraded at an agricultural trade fair as semi-naked virgins to presidents and businessmen fully clothed in Western suits. The family planning advantages of that are not immediately evident. I hope we're talking about two different things there, and perhaps the minister could clarify that. I was very grateful for the information about the legal measures that are being contemplated to further strengthen both the prohibition of rape and to encourage witnesses to come forward, I'd still be interested in further information on the implementation of the National Action Plan, Strategies 16 and 17, which provided for a whole range of measures to be taken other than measures of law, or not just limited to measures of law, designed to ensure better investigation and prosecution of the crime of rape. And I look forward to any further information the delegation may wish to provide, or indeed now, or as you will repeat yourself, sir, later during the period that the delegation has to submit information in writing. Now on to the last two issues that I have to deal with, issue 17 on prison conditions, and issue 19 on due process. First of all, in respect of issue 17, I'm grateful for the information on the percentage of overcrowding in various places of detention. The question that we asked related both to prison conditions and also pre-trial holding cells, and I'm not clear whether these detention facilities mentioned in the response in paragraph 86 to the list of issues are also places of pre-trial holdings, places where pre-trial holding cells are found. And if not, then I would really very much appreciate information about pre-trial holding cells, which we then don't seem to have here in the written response. And I would further invite the government to provide further information on the poor prison conditions. As far as paragraph 86 of the state party's reply to the list of issues, I'd be interested in knowing whether any of the, as I've said, facilities mentioned included pre-trial holding cells. I'd be grateful for information on the number of pre-trial detention cells in the country and on the issues of overcrowding and poor conditions in those facilities. This is all based on information that has been raised by the Ombudsman in 2006 and 2008, I should point out, who noted delays in processing cases, lack of cooperation between police and magistrates and prosecutors, and various other problems leading to perhaps unnecessary pre-trial detention and detention in holding cells, and there I associate myself with the issues raised by Professor Cleveland. And since she's partly covered that, I'm going, and in the interest of time, I'm going to move on to another dimension, which is the question of prison inspections. And I appreciate the replies which indicate what is supposed to happen in terms of visiting justices, but the committee has received no information that visiting judges have inspected correctional services under the Act to date. Is that wrong? Can the delegation refer to instances of justices actually exercising their powers to visit places of detention? So appreciate very much more information on this issue, and of course also information on safeguards to ensure that complainants don't risk being subject to reprisals if there are any such visits. The as we also asked for last time, we were hoping that the delegation, since the state party's written responses don't respond to the question, we were hoping the delegation might respond to the need for information about the mandate of the correctional inspector and how he or she will be chosen and the safeguards in place to ensure his or her independence. There's no mention of that in the written responses, and could I invite the delegation to give us a briefing there? We also asked the question about any plans to ratify the optional protocol to the Convention Against Torture. I should make clear that it is not an obligation under this covenant that a state party should ratify some other instrument. However, the nature of the inspection system provided for in the optional protocol is exactly the sort of measure that this committee advocates for the purposes of ensuring effective inspection and supervision, or independent inspection and supervision of places of detention. I guess if there were more information about the adequacy of that system, the issue relating to the optional protocol would not necessarily arise. The issue 17 also asked for any plans to develop alternatives to detention and whether there are any programs to educate judges and prosecutors about alternatives. I think Ms. Cleveland also raised the issue under her issue. No reply to that, and I'd very much appreciate a reply. I think there may be some plans to introduce community service orders as an alternative form of punishment for minor offences. If so, it would be interesting to know more about that and what the time frame for introducing them is. To my last issue, sir, issue 19, I appreciate the responses on the traditional courts and the limitations of the traditional courts. And as long as the limitations are respected and they don't exceed their powers, I don't necessarily see any major problem with them. Other than that, there doesn't seem to be any system of monitoring them. The state party's response says, but there's appeal from them to a magistrate's court. But I understand that that won't necessarily be very helpful to people in community courts who have no legal advice, as I understand it, in community courts, and also would not have legal advice available to them unless they could afford it, to appeal from a community court to a magistrate's court. So the question is, what plans does the state party have to monitor the actual functioning of those community courts? To some extent, I've already dealt with the legal aid issue, which, according to information we're receiving, and I'd be very reassured to have that information refuted, it's virtually impossible for anybody to get legal aid now under current budgetary restrictions, except for the most grievous crimes such as murder. I'd be very grateful to be corrected and to have that information corrected. On the issue of the treason trial, the Caprivi treason trial, there's no response from the state party to our questions there, either on the question of the nature of those who are tried and the question of the common purpose doctrine. And my understanding is that the all of those actually convicted in the end were convicted on the basis of the common purpose document, the common purpose doctrine, which, at least according to Amnesty International, may have been used, in fact, to convict what it would consider to be prisoners of conscience. That is, basically, people whose political views are non-violent political views are deprived of freedom. So, again, I'd appreciate some answers to that original question of ours, the common purpose doctrine. How does it work? How did it work in this case? Thank you very much, sir. I'm sorry for the length, but it was dictated by both the nature of the earlier responses and the subject matter. Thank you very much, sir.
Muchas gracias.
Thank you very much, Sir Nigel. And you have absolutely no reason to apologise. I'd now like to give the floor to my esteemed colleague, Ms. Pasatits, please.
Thank you very much, Chair. I would like to thank the distinguished delegation for the responses to the questions addressed yesterday in the first part of this dialogue. I would like to make a comment first. With respect to discrimination in marital and succession matters, I do welcome the delegation's response during dialogue yesterday that the bills on recognition of customary law marriages, as well as a draft intestate succession bill, are to enter into force soon, even though a precise time frame has not been given. This will be an important step, and in view, in particular, of the fact that the state party has not adequately responded to concerns which are voiced by civil society, that some discriminatory race-based practices continue when it comes to discrimination faced by women and children, in particular when married under customary law, and as regards inheritance rights, and despite the state party's affirmance that currently all children have the right to inheritance. It is one thing to have a right, it is another thing to be able to exercise that right. My questions today will focus on issue 20, 22, and 23 of the list of issues. Turning to issue 20, which relates to right to privacy, the state party is asked to provide information on the interception centers, which are provided for in Part 6 of the Communications Act number 8 of 2009, as well as information on the gathering and holding of private information under this act. The state party does give some information in paragraph 185 of its report on the staffing of such centers, but no information onto whether they are in fact operational. The response of the state party is that Part 6 of the Act establishing these centers has not yet entered into force. However, it seems that despite concerns raised during consultations of this Act, this Part 6, was not removed from the final bill. My first question would be, are such centers now operational or not? Could the state party please indicate what kind of information would be sought and what measures exist to ensure that this would be reasonable in the particular circumstances, to guarantee that interference provided for by the law is not arbitrary, but rather in accordance with provisions, aims, and objectives of our covenant and our general comment number 16. According to our general comment, competent public authorities should only be able to call for information relating to an individual's private life, the knowledge of which is essential in the interests of society as understood under the covenant. Now, there is a response in the list of issues in paragraph 103 that this act has nothing, I quote, nothing sinister about it, safe for securing the peace, order, stability, and safety of the Namibian nation, end quote. So I would like to request some further information and opinion of the state party as to whether this would comply with our covenant. A second question, related question, is to please indicate whether and by what procedure individuals have a right to ascertain what personal data concerning them is stored and for what purpose, and to request rectification or elimination of such data. Here again, the state party has not provided a response to this question, which was raised in the list of issues. And finally, please indicate the remedies available to complainants of a violation under Article 17 in such contexts. What mechanisms are in place to ensure investigation and prosecution of violations of the right to privacy? Have remedies under Article 25(2) of the Constitution been sought or granted in relation to violations under Article 17? I would be very appreciative if the state could provide more detailed information and responses. I turn now to issue number 22, which has to do with freedom of expression and to the question whether concerning conduct of research, academic freedom, and censorship of journalists and state-owned media houses. Regarding conduct of research, the Research, Science and Technology Act is coined in a very broad way. It essentially covers any research and requires any potential researcher to apply for a research permit. One could ask himself whether this act, in the way it is phrased today, is in line with Article 19 of the Covenant. As it stands, it would appear, by the definition, which is very vague, of research, that it would appear to be applicable to any research project, even, as we have been told, to an 8th grade school research project. Could the state comment on whether this act is in line with Article 19 of the Covenant? Secondly, in the light of the state party's reply that permission or authorization for academic research or projects at government institutions is necessary, I quote, for administrative purposes only, unquote. This is from paragraph 111 of the state party report. Please clarify this process. What kind of information must be submitted by researchers before, during, and after a project? Is there an application fee required? What is the time frame for authorization of such a demand? Please indicate what type of projects have been refused authorization and whether the process allows for resubmission of proposals after revision. Please indicate whether there are any criminal sanctions provided for or imposed in case of violations to this act. There has been an application to the High Court challenging the constitutionality of this act, which to our understanding is opposed to by the state party. I will not request of the state party to comment on an ongoing judicial procedure. However, I would like to ask the state party, in view of the above questions which I posed, whether the state party is considering in any way amending or abolishing this act. Turning to other issues of academic freedom in general, could the state party please indicate if it has any intention to withdraw the ban on political events on campuses of all government institutions of higher learning, which may include political events organized by students and student groups with or without party affiliations? What does the term political events include? Regarding freedom of expression and freedom of the press, could the state party please comment on reports indicating that journalists working for state-owned media practice self-censorship, that there have been incidents of intimidation of journalists by members of SWAPO, and that freedom of expression may be impacted by political party affiliation? Please elaborate on the efforts of the state party to ensure freedom of expression and freedom of the press. Could you please also inform the committee on the extent to which the Protection of Information Act of 1985 is applied? Mr. Chairman, I turn now to issue number 3 regarding protection of children. This is a long question. I will be brief and focus on certain issues in order not to take up more of the committee's time. Is the Child Justice Bill in force? We know that the Child Care and Protection Bill, now the Act 3 of 2015, has come into force, but have all the regulations been prepared? I would have to comment that this act is an extremely comprehensive act, providing a series of guarantees giving effect to the rights of child and implementing international obligations assumed by Namibia. And of course, Namibia is to be commended for the adoption of this act. But could the state party give further information, in particular relating to the human, technical, and financial resources which will be allocated for the effective implementation of this act? My second question concerns children under the age of 10 years. Have children under the age of 10 years been prosecuted for an offense? There seems to be no response given by state party to this question raised in the list of issues. Is the constitutional protection against detection for children under the age of 16 respected? And a third sub-question, state party reports that there are 2 juvenile offenders currently detained in its paragraph 122 of the responses to the list of issues. But could the state party give some data on if and how many juvenile cases are currently pending before Namibian courts? Mr. Chairman, thank you. This would conclude, for this point at least, my questions for the delegation. Thank you very much.
Muchas gracias, señora Pasarti.
Thank you very much, Ms. Pasartis. I now give the floor to Mr. Situl Singh. You have the floor, sir.
Thank you. Thank you, Chairman. I thank the delegation for the replies to the issues we raised yesterday. I also raised the issue of persons with disabilities, and that was issue number 9. And the delegation has promised to give replies on this within the next 48 hours. So we look forward to having these replies. I shall be dealing with issues numbers 24, 25, 26, and 27 this morning. Issue number 24 deals with child prostitution, and the information we have received is based mainly on the US report on human trafficking. If it is believed that this report itself is based perhaps on press articles or unverified facts, the issue number 24 gives the state party an opportunity to rebut the statements which are made in the US report. We note, however, that the replies have not addressed the questions raised to enlighten the committee on the magnitude of this problem of children as victims of sexual violence or abuse, including child prostitution. In the reply to question 24, it is stated that the police do not keep records of reported cases of child prostitution. We would appreciate a reply from the state party as to whether this problem is totally ignored. According to information received, Namibia could be a country of transit for child trafficking. Since the government does provide facilities for counseling for victims, could information be obtained from the social workers of the Ministry of Gender Equality about the number of cases the social workers have been dealing with? We have also information that a Ministerial Committee has been set up following this US report. Could we know what the Ministerial Committee has decided and what progress has been achieved in that respect? It would also appear that the Child Care and Protection Act of 2015 does not deal specifically with child prostitution, though it does deal with child trafficking in general. Could we be further enlightened about this? Similarly, the Prevention of Organized Crime Act does not make any difference between trafficking for commercial sexual exploitation and trafficking for non-sexual purposes. Is it intended to make amendments to that law in the light of the new problem of child prostitution? At least if the law makes a provision for that, the amendments could prove to be a deterrent to prevent the problem from getting out of hand. It is also mentioned in the US report that during the previous reporting period in October 2012, the Swakopmund Magistrates Court commenced the government's first known sex trafficking prosecution, where there were 3 young girls aged 13, 14 and 18 were involved because 2 suspects were charged for their alleged role in procuring these 3 young girls for sexual exploitation by a South African minor for a minor sum of $1,175 and we are told that the suspects remained in prison at that time during the case. Could we know what has happened to this trial, which started in 2014? I shall now move to issue number 25, which about the right to vote. There has been a partial reply to the issue we have raised, and so it would appear that one of the requirements for a person to be registered to be able to vote is that this person has got to be identified by someone who is already registered within the meaning of the law. Our question was, if this cannot be done, then does it mean that the potential voter is deprived of his right to vote? The reply of the state party sets out a procedure for an appeal, but we would be grateful to know if the rule that I have mentioned about identification by somebody who is already registered whether this rule is an absolute rule or whether on appeal this rule can be waived and the restriction removed. Question number 26 deals with the rights of minorities, and in the case of Namibia, it's mainly the indigenous peoples. In September 2012, the UN Special Rapporteur on Indigenous Peoples visited Namibia and produced a report and made several recommendations. We would like to know how many of these recommendations have been implemented. In that report, it was mentioned that the indigenous peoples were sometimes or more often not consulted about activities taking place in the areas where they lived. For example, in paragraph 56 of the report, it was mentioned that the Nama people informed the special rapporteur that they were of inadequate participation that they were not consulted for concerning planning and development of mineral extraction, especially diamonds in the areas where they live. Similarly, the Himba of the Kunene region noted that neither their communities nor their traditional leaders were informed about mining activities being carried out in their traditional territories and grazing lands. And there was also strong opposition by Himba, Ovazemba, Ovatu, and Ovadjimba peoples to the proposed construction of the Baines hydroelectric power project. Could we know what has happened in these cases and whether now there is a process of consultation of these indigenous peoples? Is it that some form of compensation is provided to them, even if this compensation is not necessarily of a monetary nature, but could be in terms of resettlement or at least improving the conditions of living of these indigenous peoples? We take note of the reply of the State Party concerning land tenure rights, and where it would appear that considerable effort has been made to return lands to the indigenous peoples. My question is, do the San traditional authorities have the power to administer the communal land areas which they claim belonged to them? On the issue of cultural diversity and promoting the rights of indigenous peoples in that respect, we welcome the minister's words yesterday when he stated how far education was important in a country like Namibia and how much progress has been made in that respect. But are indigenous people's interest taken into account in that respect? Has the new language policy in schools helped in reducing the number of early dropouts from school for the San and Himba children who were considered as educationally marginalized? Have the complaints of San and Himba peoples to the effect that health workers treat them poorly been attended to? Do the health workers speak the local indigenous languages? Finally, are there indigenous language interpreters in courts, tribunals, and officers of prosecutors for better access to justice for the indigenous peoples? And we also note that some traditional authorities, like, for example, the Keme, complained that they have not been recognized, alleging that probably because of their political allegiance, it has been difficult to recognize them as traditional authorities. And my last question is on issue number 27, in the list of issues where the state party has set out the process by which the country report to be submitted to our committee is how the process is carried out, and has also mentioned that the Namibia non-governmental organization, NANGOF, is also represented at the committee to represent the interest of the NGOs and civil society. However, we've received representations that the NGOs are not given adequate time to make full representations and that they are informed at the last minute of meetings taking place, so that they are not in a position to make a proper input into the report or to make comments on the report. So could you state whether this is the actual position and whether the state parties, the committee, this interministerial committee that has been set up, would be prepared to give more chances to NGOs to contribute to the state party's report. So with this, I thank you, Chairperson, and I look forward, Honorable Minister of Justice, to the replies of the delegation on the issues that I have raised.
Muchas gracias, señor.
Thank you very much, Mr. Situl Singh. I now give the floor to Mr. Olivier de Frouville.
Merci beaucoup.
Thank you very much, Chairman. And once again, my thanks to the delegation for these very many answers that they've been providing. Thank you to the Minister for making clear what he did. I wanted to confirm what the Chairman himself said. Of course, our questions do not at all touch on the question of the state party's territorial integrity, which is wholeheartedly respected by the committee. We only focus on the state party's obligations vis-à-vis the covenant. I wanted to draw your attention in relation to the follow-up to the discussion that we were having before with the state party, notably with General Observation number 31 of the committee, which summarizes the committee's stance on the nature of the obligations of the state party vis-à-vis the covenant. In paragraph 15 of this general comment, the committee says that under Article 2, para 3 of the covenant, the state's parties must ensure that anyone has appropriate recourse to ensure that their rights can be enjoyed. And in the same general comment, paragraph 18, it is reminded that when there are serious human rights violations, such as torture, summary or arbitrary executions, or enforced disappearances, then the state's parties must ensure that those who are responsible for these violations are brought to justice. We can therefore deduce from this that amnesty measures are in general prohibited by the covenant, and this is a position that the committee had already in fact taken on with respect to torture in general comment 20. Here, the committee had said that in general terms, the amnesty is not pursuant with the state party's obligations vis-à-vis acts of this nature. So this is to remind you of the general approach that underlies my questions. I wanted to ask an additional question, coming back to a question that my colleague Sir Nigel raised. This renowned treason trial and prosecuting the traitors after the events in 1999 in the Zambezi region, as you yourself reminded us, Honourable Minister. Now, according to the allegations we've received, after 15 years of proceedings, this came to trial. It's a matter of concern that those who were accused remained in preventive detention. Now, perhaps you'll correct me if I'm wrong about this, but these are individuals that remained in preventive detention throughout the 15 years of these proceedings. Now, the proceedings weren't entirely completed for everyone because it appears that 10 individuals died, even though they were detained by the police in 2003, and 12 others died in preventive detention before it came to trial. So 22 of the accused were not able to see the proceedings to their end. Another point that we'd like to have further clarification of relates to the fact that Judge Hoff, who delivered the verdict at the end of the proceedings, decided to make operational a 2001 Supreme Court decision where the court, in fact, acted pursuant to international law and to the covenant and deemed inadmissible evidence which had been obtained under duress, including witness statements elicited under torture, which is obviously a very good decision. But it is tantamount to admitting that a certain number of evidence and witness statements had been elicited under torture or under duress. And it would appear, and correct me once again if I'm wrong, it would appear that no prosecutions have been engaged against the perpetrators of these acts of coercion or torture. I would like to know whether the state party intends to initiate such proceedings and prosecutions. And still in relation to these events of 1999, and to come on to the question of enforced disappearances, in 2001, a suit had been lodged relating to the disappearance of 15 individuals within the context of these events, of people of the San ethnic group. Can the state party please tell us about the proceedings in respect of this case of enforced disappearance, which occurred relating to these events which we've mentioned? Thank you, sir.
Muchas gracias.
Thank you very much, Mr. de Frouville. I now give the floor to Mr. Boussi. Do you have the floor, sir?
شكرا سيد الرئيس. في البداية أشكر الوفد على الأجوبة التي قدموها عن الأسئلة التي طرحتها بالأمس. فقط سيادة الرئيس أظن أنني لم أسمع رد على بعض النقاط الواردة.
There is interpretation. Sorry. Yes. Thank you very much, sir. I thank the delegation for the response they made on the questions I made yesterday. Only I believe that I did not hear any response to some points in question number 14. It's a very long question that includes 6 points. I haven't heard except only one response to one point. The first point related to torture. The minister has explained that this case has been delayed due to funding shortage. However, I have another question that no reply has been given, which is related to the non-admissibility of the evidence that is extracted through confessions. I would like to know the reports that confirm the excessive use of force by the police, and that some members of the police are embroiled in the abuse of sex workers, and they oblige them to have sex with them before the release. And we also wanted some examples to condemn police officers due to acts of torture and the safeguards that were made in order to ensure the independence of police officers. I repeat these questions, and I hope that the delegate will answer even in writing. I am responsible for question number 21 related to the procedures that is taken to prevent forced marriages of children. And we requested information on divorce and the basis for the divorce, and what are the amendments that will be introduced to the Act on Divorce in accordance with the reform going on. And we also requested clarifications on the following. This Act on Divorce does not apply on the religious customary marriages, and also respond to the allegations that say that about the labia of women, the surgery that is made on girls, which might lead to divorce. You did not respond to this question, particularly when it comes to divorce, the reasons for divorce, and the basis upon which divorce taken place. You just mentioned and reiterated that the Constitution, in accordance with Article 14, stipulates equality between men and women in divorce and marriage. As for the marriage of minors, you said that the law punishes any marriage before 18 years unless there is an authorization. I would like to get information on the cases, the number of cases and the cases that were adjudicated when it comes to marriage of children. And I would like to get a response to all the points related to question number 21, related to details on the basis of divorce. And if the Act on Divorce does not also apply to religious and traditional marriages. And I would like to have legal clarifications, the difference between the traditional and the religious marriages. Thank you.
Thank you very much, Mr. Boussid. I now give the floor to my colleague, Mr. Shani. You have the floor, sir.
Thank you, Mr. President. As this is the first time I'm taking the floor, let me join my colleagues in congratulating the delegation from Namibia and welcoming it here. I have one very specific question on freedom of information. I would be grateful if the delegation could update us as to whether there has been any progress in the passage of Freedom of Information Act that would amend existing legislation on access to information, most significantly the South Africa era Protection of Information Act, and would thus give full effect to the Article 21, paragraph 1(8) of the Constitution. There have been some complaints by civil society and media that it is difficult to get access to certain public information, especially on budgetary matters. And that although the government has indicated its interest in passing legislation in this field already in the late 1990s and has published a policy paper on the issue in 2006, there hasn't been much progress in recent years in finalizing the act, and there has been little consultation with civil society since 2006 on the matter. And I would appreciate any information that you can provide us on any progress in this relationship. Thank you.
Thank you very much, Mr. Shani. Well, we've had a raft of wide-ranging questions, and of course the state will have the opportunity to respond following a break. We'll now take some time and give that to the delegation to decide how they're going to organise their responses. It's 11:30 right now, and we will come back to this room at 11:45, 11:45, to continue with our dialogue. So the session is suspended for a quarter of an hour.